So now let's look at something else that's important, and this is a commitment letter. This is very important because there are two options here. One being that the investor lender, the lender in this case, is sophisticated enough, or using a lawyer, that's going, and that person is going to provide us with a complete commitment letter. So that's the first option. They're going to give us a commitment letter, and then it's on us to look at the commitment letter to ensure that there are no errors that jump out at us. That is part of our due diligence. Or the second option is that we're not dealing with a sophisticated enough investor lender to produce their own commitment letter, and they're not having that created by the lawyer closing the transaction. So we can create the commitment letter on their behalf. That means if we're creating the commitment letter on their behalf, that means that we have to be very careful and ensure that we understand their needs and circumstances completely, and that the disclosure document, all of the risks disclosed in the disclosure are adequately reflected in the commitment letter, where the commitment letter is going to help mitigate or reduce the risks that we've disclosed. So there's a lot of responsibility when it comes to this, so it should not be taken lightly. If at all possible, have the lawyer, if the investor has, or the investor lender has their own lawyer that's done this, who is comfortable in putting together a commitment letter, have them do that. Or if you're recommending a different lawyer to act on the investor lender's behalf, make sure that you choose a lawyer who has experience in doing a commitment letter. So this commitment letter is a sample for informational purposes only. And it's broken down into different sections that make up the entire commitment letter. So I'm going to walk you through what this looks like. It's entitled Mortgage Commitment and Loan Agreement, and these are the key terms, the key facts about this commitment. The lender, ABC Network. And then there's typically a clause that says, in consideration of the mutual covenants set out herein, the lender hereby agrees to provide a mortgage loan to the borrower or borrowers on the following terms and conditions. We list the borrower, if there are any guarantors, the security, prior encumbrances. Subsequent encumbrances, we're stating they're not allowed. So if there's a prior encumbrance, that means there's a first mortgage, and we're listing out the owners of those prior encumbrances. And then for subsequent encumbrances, what we're saying is that they're not allowed to borrow additional money after we advance our loan. The total loan amount is $110,000. And by the way, this is an actual commitment letter. I've changed the names and the lender information, as well as the security information, the location, but this is an actual commitment letter that's just been modified. The advance date, if we don't know when the advance date is, we can put to be determined, or if the investor lender has a specific advance date that they wish to close by, they can put on or before or a specific date. The interest rate that they're offering, there needs to be a calculation period explaining how the interest is calculated. This is calculated and compounded monthly. If there's a lender fee, what is that lender fee? In this example, it's $5,000. The term is set for 12 months. The interest adjustment date, if there is one, in this example, it's August 1st, 2022. And the principal repayment date is August 1st, 2023. That means that in 12 months from that date, the principal amount of $110,000 is due and payable. From a prepayment standpoint, we're allowing it to be fully prepaid with 3 months interest penalty. The amortization, there is none. This is an interest-only mortgage. The payment frequency will be monthly. The payment amount, based on the loan amount and the interest calculation, is $1,100 per month. The loan may not be assumed or transferred without the written consent of the lender. And so while I'm here, want to where am I? Where'd I go? There we are. I have one too many spaces in there. There we go. Assignment, the lender may assign this loan and the security at any time without the consent of the borrower. Assignment is the way, the technical way that a mortgage is sold. So if I want to sell this mortgage, then technically I'm assigning it to another individual, and normally they'd be paying me to do that. I'd get whatever amount that we agree on, and then the payments would now be directed to the other investor. So that's where we would have an investor purchasing the mortgage from me, and I'm the lender now advancing the initial loan. And we're saying that there's no consent of the borrower required. The standard charge terms, these are standard charge terms that are filed with land registry and the number of the document, so that we can go online and look up the document. Or this is also the document that the lawyer is going to be using. The standard charge terms 200033. Postponement clause. This mortgage shall not be postponed without the written consent of the lender, which may be arbitrarily withheld. So postponement clause means that we understand that mortgages are registered in chronological order. So a mortgage that is advanced April 1st, if there are no other mortgages registered on title, that mortgage is a first mortgage. The next mortgage that's registered, maybe I'm lending that person $110,000, that mortgage gets registered on May 1st. Chronologically, the result of that is this is a second mortgage. So if the property is sold, the first mortgage gets paid first, the second mortgage gets paid with the proceeds of that, the remaining proceeds. Now, if the borrower wants to refinance the first mortgage, technically what happens is the lender says, okay, I'll refinance this mortgage. I will increase the amount, or maybe the refinance is just a change of terms. But what they have to do is technically discharge that first mortgage. So they register the discharge of charge on title, and what that does is it nullifies the mortgage that was registered on April 1st. So there is no longer a valid mortgage from April 1st. The only valid mortgage now is my mortgage that was advanced on May 1st. The lender that is refinancing that first mortgage is now going to register the refinanced mortgage on title. So what we'd see on the parcel registry, which is where all these documents are registered, is the first mortgage, then my mortgage, then a discharge of the first mortgage, then a registration by the lender, that first mortgage lender, of a new mortgage. Looking at chronologically, that would mean that my mortgage is now a first mortgage, and the original lender's mortgage is now a second mortgage. The first mortgage holder is not going to do that. They are refinancing the mortgage, typically to lend more money to the borrower at favorable terms, and they're not going to then go into second position. So consider if you had TD Bank as the first mortgage holder and I'm a second mortgage holder, they're not going to discharge and let me be the first and them a second. So what they would require is a postponement clause. That is, or a postponement agreement. That is an agreement that me as the second mortgage holder would put in writing saying that I understand that even though my mortgage is chronologically ahead of the mortgage registered after me by TD Canada Trust, that I postpone my rights to TD Canada Trust. So TD Canada Trust, in essence, now, even though their mortgage appears registered on title after mine, they are going to get paid out first if there's a sale of the property, and then I would get paid out second. So even though on the parcel registry it appears that I have a first mortgage, I don't because of the postponement agreement registered on title. That's what this is saying, that the mortgage shall not be postponed without the written consent of the lender, which may be arbitrarily withheld. There's no requirement for the second mortgage lender to provide a postponement agreement. Oftentimes, the second mortgage holder will provide a postponement agreement if it's in their best interest. If, for example, the first mortgage is being refinanced with better terms than the initial mortgage, so it's improving the borrower's position, maybe increasing the borrower's cash flow. It depends, Bashid is saying, but in that case, the private lender risk is increased. If they postpone based on the first mortgage lender increasing the size of the mortgage, it may increase the risk of the second mortgage lender, depending on how much equity is there. If the first mortgage is a 20% loan to value and the second mortgage is a 5% loan to value, and they want to increase the first mortgage amount to 30% loan to value, then the total exposure for the second mortgage holder is 35% loan to value. I'd be inclined to do that, depending on the purpose of the refinance of the first mortgage. So it depends, right? And that's why it may be arbitrarily withheld, because you would have to approach the second mortgage holder and make a case to them as to why this is in their best interest to do that. That makes sense, Bashid? Awesome. Okay, in this condition, in this commitment letter, we have preconditions to the advance. So these are conditions that must be met before this commitment is going to be considered to be binding. The preconditions to advancing the funds: the borrower to provide proof that the property taxes for the property is in good standing. The borrower to provide proof of fire insurance coverage on the subject property for full replacement value in favor of the lender and in form and substance approved by the lender. These form the instructions to the lawyer. The borrower to have good and marketable title to the property in fee simple, subject to no outstanding interests, encumbrances, or defects, except that may have been stated in the commitment that we know about. Typically, they're not going to be any. And what that means is that good and marketable title to the property in fee simple means that they own the property as fee simple ownership, and there's nobody else on title other than the ones we know about, and there's no outstanding liens or other interests registered on title, or any defects in title unless we know about them and we approve them. Title insurance in favor of the lender in form and substance approved by the lender, and such other security as the lender's solicitor in his/her sole and absolute discretion deems necessary. This commitment is fully revocable by the lender at any time prior to closing. So that's another great protection for the potential investor lender, and that is, if I'm putting this out, I can revoke it at any time before money actually is advanced through the lawyer. So time is always of the essence. There's a clause all over the place that you'll see. Time is of the essence. That is that we want to get this done quickly so that nothing changes materially, and it's everybody's intention to not delay the process. Section 3, we have signatures. So we're going to have it dated by the lender or the lender's representative. And we are going to have the borrower accept it and sign this as well. Then any attached schedules or like addendums. Schedule to charge of land made between Mrs. Borrower as owner on title for the chargor and ABC Lending, the chargee, properties to be secured. We have the address of the property and then additional provisions. Notwithstanding anything contained in the set of standard charge terms, the following provisions apply. So we can add or modify anything that may already be in those standard charge terms. The standard charge terms of those is the standard charge terms document that provides the bulk of the contract for the loan. And now we're going to add anything that we might want to add to customize it. The term, it's going to commence on August 1st, ends on August 1st, 2023. The charge shall be fully open as long as the borrower is not in default, and as we saw before, 3 months interest. For the purposes of the calculation of interest, any payment on account of the money secured under the charge received after 1 p.m. shall be deemed to have been received on the next following banking day. You know, the devil's in the details, right? The monthly installment shall be paid on the first day of each and every month, provided that in the event that the chargor shall sell, transfer, convey, or otherwise dispose of the within lands, then this charge shall become due and payable immediately upon such sale, transfer, or conveyance. So if the owner of the property is transferring title or ownership to somebody else or is selling the property, the mortgage obviously has to be paid in full. In the event that the chargor further encumbers the subject property without the consent of the chargee, the entire principal then outstanding together with all accrued interest shall forthwith become due and payable in full on demand, together with and without limitation any related legal, administration, penalty, fees. And what we're saying here is that we've told you you can't have another mortgage on this property, and if you do that, we are going to demand payment in full. And we may, if there's a penalty, the 3 months penalty, we can charge you that. Legal fees, we can charge you that. And if there's an administration fee that we've included, we can charge you that. Post-dated checks, the borrower is going to provide the lender with a series of personal post-dated checks on the advance of funds. So the borrower is going to give this to the lawyer. And on each anniversary date of the interest adjustment date for all the payments in the each ensuing year. Otherwise, the chargee shall not be obliged to advance any funds hereunder. So in other words, if you don't give me post-dated checks, I'm not going to give you the money. If you bounce a check, in other words, the technical language is if a post-dated check is not honored when presented for payment to the bank on which they are drawn, the chargor shall pay to the chargee for each returned check $250, not as a penalty, but as a liquidated amount to cover the chargee's administration costs. If upon default, inspections or attendances at the property are required or deemed advisable by the chargee or its agent's employees, for each inspection or attendance at the property, the chargee agrees to pay the sum of $500, or the chargor agrees to the chargee. So, you know, hey, if you default on the mortgage and I got to go inspect it and make sure it's okay, there's another administration fee. I'm going to charge you $500. Any and all costs incurred by the chargee hereunder for, but not limited to, the collection of overdue interest, principal, taxes, insurance, solicitors' fees, disbursements, plus HST, or other costs incurred or payments to be made pursuant to provisions of this charge to be paid by the chargor, and shall include all costs, whether such are deemed necessary or unnecessary. That's, you know what, you're responsible for all of these additional fees. If I need to provide a statement, there's going to be a fee. If there's an assumption, then there's going to be a fee, and they are to be payable by the chargee. And if not paid, they'll be added to the mortgage and interest will be charged on them. To discharge, the chargor shall be responsible to pay all expenses relating to the discharge of this charge, all legal, administrative, and administrative fees. What that means is that when you pay the mortgage off, so at the end of this August 1st, 2023, when the borrower gives the lender $110,000 back, the lender says, thank you very much. Here's your receipt. You've paid me back. And if you want to register a discharge on title to show anybody else that you don't owe me this money anymore, that's on you. You got to pay for that. Realty taxes and utilities, the chargor covenants to provide evidence of payment of realty taxes and utilities on demand. Fire insurance has to be in place in favor of the chargee. And if you do anything that is considered criminal at the chargee's sole and absolute discretion, the mortgage will become due and payable in full, and the chargee can exercise all of its right. And if any person conducts criminal activity or of any kind, or cultivates and possesses marijuana or other substances, the possession for distribution of which may be contrary to applicable law on the property. Postponement, this mortgage shall not be postponed without the written consent of the lender, which may be arbitrarily withheld. And as I discussed about the postponement already, we've talked about that in detail. Whoops. And that constitutes the balance of the commitment letter. So you'll see these additional clauses. In many cases, what you'll see is the lender in the instructions to the lawyer saying that we want these clauses in the commitment letter added as a schedule to the standard charge terms, so that they all form part of the loan agreement. And then it's up to the lawyer to fulfill those instructions and do everything that we've seen that were included, all of those clauses that were included with the fire insurance, title insurance, and so on. All of that has to be conducted by the lawyer before they can advance funds on behalf of the lender. So there's a lot that goes into this, and you can see why at this stage we're all here, because it's very easy to make an error if you are the one creating the commitment letter. So it's very important to understand what our obligations are and to have a lawyer specifically. Whenever I do private lending, I don't do the commitment letter on my own behalf. I make sure that my lawyer does it, just because the lawyer is E&O protected as well. So in case there's a mistake or anything like that, it's E&O protected on the lawyer. But if I was doing this on behalf of another lender, a private lender, I would look at their commitment letter and go through it and see if there were any mistakes or any errors that I needed to point out, or anything that I might, suggest to the potential lender be included. For example, the postponement clause, criminal activity, and other clauses that may not be included in a commitment letter that a private lender sends to me. I would then make suggestions to them that those clauses be included. At the end of the day, the investor lender disclosure and commitment are designed to provide information, the investor lender disclosure information to the potential lender. The commitment is designed to provide information to the borrower as to what the lender expects and will agree to in exchange for the money. And we have to make sure, as part of our due diligence, that things are done accurately and correctly in relation to the level of risk and what the lender actually wants to happen, what clauses the lender wants. We can add different clauses in here when we're talking to the lender. If the lender wants a different NSF fee or has other, other requirements then that are unique to that particular private lender, we can include them in the commitment letter. But at the end of the day, it's important to understand what these documents are and what they represent. So those are all the different sections in the commitment letter.